If you're going to make a will in England, you have to have what's called testamentary capacity. And the test for whether you have it or not is set out in the 1870 case of Banks and Goodfellow. And the judge in that case said, in relation to the person making the will, that no disorder of the mind shall poison his affections, pervert his sense of right, or prevent the exercise of his natural faculties, and that no insane delusion shall influence his will in disposing of his property. Right. So in English, that means that the person must understand the nature of the will and its effect, have some sort of idea as to the extent of their property that they're disposing of, and be aware of who they'd normally be expected to provide for, even if they decide not to. And now we've got a modern test for mental capacity in the Mental Capacity Act 2005, and that takes a slightly different tone. And that says that the person is assumed to have capacity unless it's established that they lack it, and that a person lacks capacity in relation to something in particular if at that material time they're unable to make a decision in relation to that particular matter because of an impairment of the mind or the brain. And then the Act goes on to define what unable to make a decision for themselves means, and that is that if they can't understand the information relevant to that decision, retain that information, use that information as part of their decision making, or communicate that decision, whether by talking or using sign language or some other means. In 2015, in the case of Walker and Badmin, the court said that the correct and only test is the one that's set out in Banks and Goodfellow. And they went on to say that the Mental Capacity Act was only ever intended to deal with living people, and not to decide after someone's died whether or not they had capacity. And that's got to make sense. And in any case, where there's any doubt, perhaps the person is ill or older, there's always a golden rule, and that is that the will ought to be witnessed by a medical practitioner. Now, that's a bit of a contentious point, because some people say that that's ageist, or that perhaps it puts the medical practitioner in a bit of a sticky situation. And I always say, if you're not sure, take advice, otherwise you're going to end up having a ding-dong, and nobody wants that. If you want some advice on your will, then please get in touch. Otherwise, if you'd like to subscribe to my YouTube channel, please hit the subscribe button.